Hello, and thank you for joining us. My name is David Gabor, and I'm joined by my colleague, Catherine Brustowicz from the Wagner Law Group. We're going to talk today about some significant developments regarding the classification of workers as independent contractors. We will review some changes that employers should be aware of and steps that they can take to deal with the changes. We are then going to shift gears and talk about some developments regarding the classification of employees as exempt and non-exempt. Catherine, can you please walk us through the agenda and the goals for the program today?
Absolutely. Thank you, David. As David mentioned, our two main focuses are going to be the DOL's new independent contractor final rule, as well as employee classifications as exempt or non-exempt. Specifically, we'll start off by discussing what prompted the changes to the independent contractor rule. Then we'll delve into the changes themselves in detail. Next, we'll review the impact of the rule and concrete steps that employers can take right now. Then we switch over to exploring recent developments regarding employee classification, and that is namely the final rule that impacts overtime protections by increasing compensation thresholds. We will also review further steps that employers can take with respect to that new rule. And as we do with all of our webinars, we will conclude with our top 10 list. So without further ado, let's jump into what prompted the DOL's changes to its guidance. The department believes that the 2021 independent contractor test did not fully comport with the text and purposes of the FLSA, and that's the case as was interpreted by the courts. The prior rule had used 5 economic reality factors, with some factors being prioritized. And as you will see, this has been changed to 6 factors, with no one factor presumed to carry more weight than another. Some provisions of the 2021 rule conflicted with the DOL's prior guidance as well. For example, the economic reality test was narrowed by limiting the facts that could be considered in the analysis. For instance, under the 2021 rule, the workers' investments and initiatives were considered only as a part of the opportunity for profit or loss factor. The rule also had prohibited the consideration of whether the work performed was central to the employer's business. The rule was viewed as making it easier to classify workers as independent contractors and was viewed as being a business-friendly rule. Ultimately, the Department of Labor believed that leaving the 2021 test in place was confusing and departed from decades of case law describing the multi-factor analysis. Before jumping into the changes themselves, I wanted to remind us that the reason there's a rule in the first place is because the FLSA does not indicate how to classify a worker as an employee or independent contractor. Now let's take a look at the changes to the DOL's guidance. To put it as succinctly as possible, the new rule rescinds the 2021 independent contractor rule and replaces it with guidance for how to analyze employee or independent contractor classification that is more consistent with the FLSA. The final rule applies a 6-factor test in determining whether a worker is an employee or independent contractor under the FLSA. It is a fact-intensive test, and the test is similar to guidance issued and case law decided prior to 2021. The economic reality factors are all weighed to assess whether a worker is economically dependent on a potential employer for work, according to the totality of the circumstances. That means that no single factor is determinative of the classification. Remember that where the worker is dependent on the employer for work, they will be deemed an employee under this rule. Now, David, can you please walk us through the 6 factors and how they weigh either in favor of classifying the worker as an employee or as an independent contractor?
Sure, thank you, Catherine. So the first factor is the opportunity for profit or loss depending on managerial skill. Considerations are whether the worker can negotiate fees, engage in marketing, advertising, or other efforts to expand the worker's business. Deciding to work more hours or to take on more jobs at a fixed rate typically would not require the exercise of managerial skill. The second factor, investments made by the worker and the potential employer. The DOL's guidance attempts to draw a distinction between a worker's investment that is capital or entrepreneurial, whether they, quote, support an independent business and serve a business-like function, such as increasing the worker's ability to perform different types of or more work, reducing costs, or extending market research, close quote. That's from the DOL, as compared to the employer's investment in the overall business. That a worker purchases tools and equipment for a specific job as requested by the employer would tend to indicate that the worker is an employee and not an independent contractor. Tools that the worker purchases on the worker's own initiative may indicate that the worker is an independent contractor. The third factor, degree of permanence of the work relationship. Relationships that are fixed for a period of time, are non-exclusive, sporadic, or where the worker can market services to multiple entities suggests that the worker is an independent contractor. Conversely, an indefinite relationship, continuous or exclusive of work for other employers, is indicative of an employer-employee relationship and not an independent contractor. The fourth factor, the nature and degree of control. The more that the employer sets the schedule, supervises work, or disciplines work, the more likely that this is an employer-employee relationship. Other factors include placing demand or restrictions on the workers, controlling fees or prices, and not allowing them to work for others is evidence of an employer-employee relationship. The change in the rule involves when action is taken to comply with federal, state, local, or tribal laws or regulations. Steps taken to comply with these laws would not affect a worker's classification. However, when an employer goes beyond specific legal requirements, this may affect the analysis. The fifth test, the extent to which the work performed is an integral part of the potential employer's business. Here, the focus is on whether the work performed is integral to the business. If the work is not critical or necessary for the organization's primary purpose, then this likely would favor an independent contractor classification. And finally, skills and initiative. The rule provides that specialized skills alone do not indicate that the worker is an independent contractor. When the worker utilizes specialized skills that contribute to a project, that factor will favor classification as an independent contractor. Where workers rely on the employer for training to perform the work, this factor favors classification as an employee. So let's talk about the impact. Employers are encouraged to rethink their analysis to determine if a worker is an employee or a contractor. And, we can change our methodology and apply new protocols when conducting the analysis. What I recommend you do is update your policies to reflect the changes in the guidance for the classification of employees and independent contractors. If you don't have a policy, I think it's a good time to create a policy. Then think about the people who work with the contractors. Those who supervise contractors should be made aware of the policy and should be given some level of coaching and instruction of what they can and cannot do. Essentially, talk to them about their authority, because the more they're controlling what a contractor does, the greater the risk that the person will be classified as an employee and not an independent contractor. So we need to make sure the supervisors understand their role in the process. And lastly, and this is important, this is one of those times where you take out your writing stick, pen, pencil, crayon, whatever it is that you write with, and centralization of the process. One of the things that Catherine and I see all too often is people are brought in as independent contractors and the process is decentralized. And why that matters is if people can bring someone in without checking with HR or legal or the COO of a business, then you're at risk of a misclassification. And those are avoidable mistakes. So let's jump into some other steps employers can take, that being the first one. And I'd like to talk about assumptions because all too often you've got somebody who's been performing services for a period of time and they're helpful to the team. They get paid. They're working as an independent contractor. So we assume, well, they've been an independent contractor for a while. What's the harm? Let them continue doing what they're doing. It's easy to make that assumption. And that's an assumption when we talk later on about exempt versus non-exempt that we should be avoiding. Auditing. I know you're going to roll your eyes at this one because who's got the time to do it? Who's got the resources sometimes? Audit the independent contractor relationships with the business and consider the 6 steps we talked about and some of the analysis that Catherine also offered. Contractual language. And this is where it gets interesting. And I know that there are several people who are on the call who are working in the financial advisor space. Here's the deal. If you look closely at your contracts and you're proactive, in terms of what you put in the contract, you can make a profound difference. The devil is in the details. If your workers have a separate business, i.e. their own tax ID number, that could be a viable workaround for them so that you can have them working with you. Financial advisors are often concerned that the rule may reclassify them as employees of a broker-dealer firm, but arguably, if the financial advisors retain control over the firms with whom they work, control the design of financial plans, and continue to dictate the specific services they provide and pursue their own marketing and autonomy, they won't necessarily be considered employees. Keep in mind the 6 factors we just reviewed will all be weighed in making the classification determinations from them. And another thing to think about is whether the tasks are things that should be handled by an employee or not a contractor. There are times where you bring a contractor in and you figure, well, we could save money. We don't have to worry about benefits for them. We don't have to worry about overtime, retirement plans, what have you. And we could save a bit of money by working with contractors. But when we don't have the same kind of control over what they're doing, this may not be a good business decision because it could have an impact on your brand. And sometimes it's actually easier to train employees who are going to stay with you for an extended period of time and have them provide those services. So, Catherine, what's new in the world of exempt and not exempt?
So the biggest development in the world of exempt or non-exempt employees is the Department of Labor's new overtime rule. Just for clarity, we are now firmly in the realm of employees. It's important to remember that the FLSA does not apply to independent contractors. So this new rule raises the salary threshold levels in 2 separate phases. It's currently $35,568 being the annual salaries. But as of July 1st of this year, workers earning less than $43,888 annually will have to be paid overtime, even if they're classified as a manager or a professional. In January of next year, on the 1st, the salary threshold will rise again, and it will increase to $58,656 annually. And also the rule includes an automatic salary threshold increase every 3 years. So this is something that's not going away. And remember that workers who fall under the FLSA's executive, administrative, professional, or computer and outside sales exemptions are not eligible for overtime pay. And to qualify for these exemptions, employees must be paid a salary of at least the threshold amount and meet certain duties tests. And of note, no changes are being made to the duties test. If the employees are paid less and they do not meet the tests, then they must be paid time and a half, so 1.5 times their regular hourly rate for any hours worked in excess of 40 hours in the work week. Now, the rule also applies to highly compensated employees who perform office or non-manual work and are paid at least $107,432 or more annually. They're considered exempt from overtime if they customarily and regularly perform at least one of the duties of an exempt executive, administrative, or professional employee. And effective as of July 1st of this year, the final rule will raise the thresholds for highly compensated employees from $107,432 to $132,964 annually. And the threshold here will again increase on January 1st up to $151,164 annually. So what should employers do now? In light of this new final rule, employers should perform an analysis to determine which positions will be impacted by the salary threshold increases. Employees who meet the duties test, but not the new salary thresholds, should be treated as non-exempt employees. In other words, they should be paid time and a half for any hours that they work over 40 in a week. However, employers may find after careful review that it will actually be more cost-effective to increase salaries for certain positions so that those employees would continue to meet the FLSA exemption as an executive, administrative, or professional employee. Now, I would be remiss if I didn't mention that a review of state law should also be performed to determine what impact, if any, the new thresholds may have on determinations of exempt employee status at the state level. The last bullet point on this slide is with respect to notice. So the changes to the thresholds and the impact on employees needs to be carefully communicated. Employers should carefully draft and send a notice to affected employees explaining why they are now eligible for overtime or why their salaries are being increased, and also any additional impacts that the changes might have on the employees. For example, non-exempt employees perhaps will need to get authorization before they start working overtime hours. And the distribution of the notice should also be carefully timed just in case the final rule ends up being delayed. So I've just reviewed some steps that you can take to minimize your risk, but why bother? Well, it can be extremely costly. Here are some of the damages associated with misclassifications. If an employee is misclassified as an independent contractor, though they're actually working as an employee, the damages include unpaid wages and overtime, double or even treble damages, depending on the state, lost benefits, attorney's fees and costs, and there's employment tax liability as well. This can include 100% of the combined worker-employer contribution under FICA, and then there's also penalties and interest. If the misclassification affects multiple workers over a period of years, the total amount of these penalties can actually be staggering. Also, willful violations of the FLSA can result in a fine of up to $10,000 or a term of imprisonment of up to 6 months or both. So you don't want to accidentally violate the FLSA, but you certainly don't want to violate it intentionally. There are also some complications with respect to plan administration that can stem from misclassification. For example, retirement plans and health and welfare plans. Now, don't forget that the final rule only revises the department's interpretation under the FLSA. It has no effect on other laws, federal, state, or local, that use different standards for employee classification. So keep in mind that businesses must comply with all federal, state, and local laws that apply, and ensure that they're meeting whichever standard provides workers with the greatest protection. The same damages are available if an employer misclassifies an employee as exempt when they shouldn't have been exempt. The aggrieved employee may recover unpaid overtime and liquidated damages for at least the 2-year period from the date of the claim, and up to 3 years if the evidence establishes that the employer willfully misclassified the employee. So now that we understand how costly these misclassifications can be, David, would you mind suggesting some further steps that employers can take to reduce their liability?
Thank you, Catherine. And folks, we are sorry that we had to share what potential damages are, but that's our responsibility because we really do want to keep you out of trouble. Catherine discussed steps of doing in order to determine which positions would be impacted by the salary threshold increases that accompany the new overtime rule, and then deciding whether to increase the salaries or reclassify as non-exempt. Here are a few more steps that you can consider. The first and foremost is stay current on the rules. There are developments that come out on a regular basis impacting the employer-employee relationship. Make sure that you've got somebody who's letting you know about the rules because, as Catherine said, you don't want to make a mistake that leads to misclassification because there still are potential damages that can be enormous. So stay proactive. Uh, Keep up on the rules. Make sure that you've got a plan in place to make sure that you're applying the rules properly with respect to classification of employees. And one of the other things we've seen in several cases over the last couple of years, and this is especially so after the pandemic began in 2020, and that is that you've got a job description and it looks a lot like this person in that job description is exempt. But is the person actually doing what's in the job description, or has their role changed? For example, if we've got people who are remote and they are no longer managing 2 or 3 people in an office, and the basis for the exemption was that they're managing people, they're no longer exempt. A salesperson who is not predominantly on the road selling may no longer be exempt. So please take the time to make sure employees are actually doing what's in the job description, because those steps will make a big difference, huge help for you. And the last one, I know I said it when we were talking about independent contractors and employees, but be careful with assumptions. Well, this person is in a role that's exempt, therefore they are exempt going forward. Let's just make sure that we're not making that mistake. And as Catherine hinted at a little bit ago, we do like to do a top 10 list. And it's not that we want to be on the Tonight Show. I'm not David Letterman, although I have the same first name. But we do like to do this because we try to give you some takeaways that you can bring back to your teams and say, I picked up a couple of things on this program. So Catherine, can you kick it off, please?
Absolutely. So the very first bullet point here on our top 10 list is when in doubt, classify as an employee and not exempt. The law presumes that every worker is an employee, and the employer has the burden of overcoming that presumption for lawful classifications of a worker as an independent contractor. When in doubt, it is much safer to simply classify the worker as an employee. Also, based on the risks and damages that we discussed, it does make good business sense to also classify employees as non-exempt from overtime if you are in doubt. Now, the second bullet point here, the key impacts from the Department of Labor's final rule on independent contractors. Really, to summarize it and truncate it down to basically one sentence, a worker is not going to be considered an independent contractor if they are, as a matter of economic reality, economically dependent upon an employer for work. Now that simplifies it quite a bit. Of course, there is the 6-factor analysis that has to be done. But if you remember one thing about this rule, if the worker is economically dependent upon the employer for work, they're probably not an independent contractor, and instead they should be classified as an employee.
Okay,
David, did you want to hit the third one?
Sure, thank you. I like that succinct definition in number two. Um, we talked a bit earlier about auditing, and one of the things I wanted to add to this is there have been occasions where a person who was misclassified as a contractor, led to the company saying, I didn't even know that person was an independent contractor working for us. We do see that sometimes where a person has just been performing some work, getting checks, and leadership did not even know about the relationship. So either talking to your CFO, accountants, tax people, find someone who's going to be able to identify people who are getting paid on a regular basis for work for the company, because it's remarkable, but we do have those cases where, to say, I didn't know the person was a contractor working for us. So for starters, we need to know who's out there, and then look at the length of the relationship. And if it's an indefinite term, as we talked about earlier, likely that could be an employee. So start with that. Start with those two items. Find out who is in your potential population of contractors, the length of the relationship, and then go into the definition of the relationship. What type of agreements exist when you conduct your audit? I know I mentioned it earlier, but it's a very important point. Like when we do programs regarding how you pay your employees, how much they get, you want to centralize the process. Same is true of independent contractors. Who in the company has the right to enter into a relationship with a third party who we are going to call an independent contractor? Control who has that right, who has that authority. And if you centralize that process, then you're going to avoid a lot of risk. And finally, updating the independent contractor agreements. You have an agreement with somebody who's providing services as a contractor, take a look at the agreement. Apply the 6-factor test to that relationship. And there are instances where you can change that agreement so you can continue to work with the person as an independent contractor. For example, do they have a right to work for other companies? Do they have a tax ID number? Who's controlling when, where, and how they work? Do they have an opportunity for profit? Those are things that you can address in a contract, and that would help you go a long way towards avoiding any kind of trouble down the road. So, Catherine, do you want to switch gears and talk about exempt and non-exempt?
Absolutely. So this bullet point here is with respect to steps in auditing exempt or non-exempt employees. So make sure that you take a look at the employees' salaries and see where they stand with respect to the salary threshold. That's a clear-cut, pretty easy thing to do. Keep an eye on the dates when those thresholds are going to be increasing, and keep in mind again that after they increase in July and again on the 1st, that every 3 years we'll see a sequential increase. Then once you've got a solid handle on the salary threshold, drill down on the duties that these employees actually perform to see if they fit within any of the FLSA's exemptions. I'm going to speak a little bit more about the importance of the actual duties and how those are described within the job descriptions when we get to the last bullet point. But it's really important to ensure that the duties that the employee is actually performing are spelled out very clearly, and that's going to help you to determine whether they fit into any of the overtime exemptions. Number 7, be strategic regarding the change in the salary threshold and make a business decision between raising salaries or paying overtime. Employees who meet the duties test but do not meet the new salary threshold should be treated as non-exempt employees. Though, as I mentioned before, an employer may determine that it's actually more cost effective to increase salaries for those certain positions so that those employees can continue to meet the FLSA exemptions as either an executive, administrative, or a professional employee. David, we talk about it all the time, but do you mind just discussing the importance of proper documentation?
The good old D word. Sure, Catherine. Um, it's a good idea to document the analysis you use when determining whether a person is exempt or not exempt. What are the steps you take to make that conclusion and then maintain those records throughout the time that the person works as an employee of your business? I also recommend tracking the hours. Um, this is important for a host of business reasons. How long does it take to get projects done? How many hours are these people working? But also, if you have a close call and you err on the side of allowing the person to work as an exempt employee and you track the hours, then you actually know if there's an issue down the road, how many hours they worked. So, for example, a person says, I'm working 55 hours a week and I'm not getting paid any overtime, and you're tracking their hours and they're only working 40 hours a week. That's your evidence down the road if you ever have to justify how you paid that person, which leads me to number 9, and that's error on the side of caution. If you're not sure whether the position is or is not exempt, treat it like it's not exempt. Pay overtime if the person does work overtime, control how many hours they work, um, but err on the side of caution. It'll cost you an awful lot less money to pay a small amount of overtime than face the damages that Catherine described about 15 minutes ago. And Catherine, can you close out the session, please?
Absolutely. So the last one on this list is update job descriptions to match what employees are actually doing. So remember that job titles and job descriptions do not determine exemption status. It is a combination of the actual duties that the employee performs, as well as their salary, that determines whether they're exempt or not. And that wraps things up. David, did you just want to thank our audience and bid them adieu?
Absolutely. We threw a lot of information at you in the last half hour. If you want to speak to us, please feel free to reach out to Catherine or to me. We do put out fires when our clients do have litigation, but what we love more than anything else is being proactive with our clients to keep them out of harm's way. So do feel free to reach out to us. And if there's other topics you'd like to have us talk about in webinars going forward, let us know, and we'd be happy to put together additional webinars. Have a terrific day, and thank you so much.
Thanks.